Hello everyone, welcome to Legal Darshan. In today's video, we are going to discuss case number 3 in the list of leading cases for the AOR examination 2025. The case being Minerva Mills Limited versus Union of India. Now, Minerva Mills is supplementing to what has happened in Keshwanand Bharati's case. The verdict in Keshwanand Bharati's case is being supplemented by the verdict in the case of Minerva Mills versus Union of India. Now, what is happening? Minerva Mills is involving an issue of nationalization of Minerva Mills, which is located in Bangalore, because this mill was undergoing several losses. Now, the nationalization of the Minerva Mills is in challenge in the case already, and because nationalization was an entity in Schedule 9 of the Constitution of India. Now, that is in challenge, and significantly, what happens is in 1976 the amendment come 42nd amendment come, which we also know as the mini constitution. And what is happening by 42nd amendment, we are adding two articles in article 368, two sub articles clauses in article 368. Now clause number 4 and clause number 5 gets added by virtue of the 42nd constitutional amendment act. Now if we come to clause 4 and clause 5 of the article 368, the article is basically laying down the power of parliament to amend the constitution. Article 368 lays down how a parliament is capable of amending constitution, and provision in clause 4 and clause 5 are being added through 42nd amendment act. Now provision in clause 4 reads that no amendment of this constitution, including the provisions of part 3, made or purporting to have been made under this article, whether before or after the commencement of section 55 of the Constitutional Amendment Act 1976, shall be called in question in any court on any ground. So basically what is happening when we are talking of Keshwanand Bharati is saying that if you are bringing amendment, that will be subject to the basic structure doctrine. Now here in the court is the parliament is bringing in an amendment, and it is saying, because we know that in amendment number 24th we have inserted that any amendment will not be law in the purview of article 13 clause 2, right? And now this article is adding to it, saying that if any amendment has been made by the parliament, whether before or after commencement of the 42nd amendment, section 55 of the 42nd amendment, which was providing for this clause, it cannot be subject to any question in the court of law. So basically, barring the judicial review on any amendment so made, because Keshwanan Bharati is telling you that your amendment is subject to judicial review, your amendment is subject to basic structure doctrine. But significantly, in 1976, just 3 years down the line, the mini constitution amendment comes and Parliament say, whatever amendment we make, it is settled that it's not a law in the ambit of Article 13. So it will not be subject to judicial review in the scope of Article 13. Clause 5th here is the removal of doubts clause, and it is saying that it is hereby declared that there shall be no limitation whatever on the constituent power of parliament to amend by way of addition, variation, or repeal the provision of the constitution under this article. So now what is happening? So basically, if you look at the clause 5, it is giving parliamentary supremacy. It is giving more parliamentary supremacy than the constitutional supremacy. Okay, so because this provision is saying that no limitation, there is no constraint, constitution will not put a constraint if parliament wants to amend, vary, or repeal any provision of the constitution under this article. So any provision can be amended in the constitution by exercising article 368 powers by the parliament. Okay, so what is happening? We believe in the supremacy of law. In Keshwanand Bharati, judicial review was basic structure doctrine. Supremacy of constitution, supremacy of law of the land is forming the part of basic structure doctrine. Judicial review is one. And of course, unfettered power is not acceptable in the legislation. So Keshwanand Bharati is laying down. And to overrule what has been said in Keshwanand Bharati, Parliament is coming with this kind of amendment. Now in Minerva Mills, this amendment is coming in challenge before the Supreme Court of India. So Supreme Court is basically again reiterating what has been held in Keshwanand Bharati, and it is saying that if you give unfettered discretion in the hands of legislature to make any law, any amendment, the power will be exercised arbitrarily, it will manifest arbitrarily, and will be a gross violation of the constitutional guarantees that has been given to all the citizens of the country in the Constitution of India. Thus, the court in Minerva Mills is reiterating back to the case of Keshwanand Bharati, which was just decided 7 years before the decision that came in this judgment. And it is saying that the addition of Clause 4 and Clause 5 in Article 368 is unconstitutional because it violates basic structure doctrine. It is not confining with the basic structure doctrine and therefore unconstitutional. So that to the effect that section 55 and section 4 of the amendments, Constitutional Amendment Act, were rendered unconstitutional on the ground that they were violating the basic structure doctrine and the judicial review. Because if you look at Clause 4 and Clause 5, they are putting a direct bar on any amendment that may come in the Constitution, or they are putting a bar on the judicial review. Okay, so one day, if we keep this provision intact, what happens if one day constitution the fundamental guarantees are revoked? Because in Article 368 subclause 4, it is mentioning that it includes the amendment is inclusive of the amendment in the provision of Part 3. So what if Parliament one day decides that we are revoking the guarantees given to you? That will be an exercise of unfettered discretion, and which will subject people to discrimination, subject people to loss of their rights, strip of their fundamental guarantees, and it will go against the spirit of the Constitution of India, right? So a court here is reaffirming Keshwanand Bharati. Court here is looking at reaffirmation of two principles, that judicial review is absolute, because if you bar judicial review of parliamentary amendments, you are also violating doctrine of separation of power, because in separation of power, it is the work of judiciary to protect and interpret the law. So if you hamper that power by a legislative action, then you are also barring separation of power, you are also barring judicial review. And ultimately, when you are considering that Parliament has all the power, unlimited power to repeal, add, or vary the provisions of Constitution of India, what you are doing is you are minuting, or you are diminishing the supremacy of law, the supremacy of the Constitution of India. You are basically promoting parliamentary supremacy and suppressing the democratic supremacy of people. To protect the people of India, we do have the Constitution, right? So this first question was answered in Minerva Mills, holding that Amendment 42nd, which is providing that 368(4) and 368 Clause 5 shall be inserted, will be unconstitutional and thus will not take effect. But it is coming with the second question also. The court herein is looking at Article 31C. Article 31C is also looked herein, and Article 31C is providing that if there is a question of directive principles, which is Article 38 and 39 in the Constitution of India, the law is such that to promote what is there in Article 38 and Article 39, primacy shall be given to DPSP, and that primacy shall override Article 19 and guarantees in Article 14 as well. Okay. So now what is happening in Minerva Mills is that there is an act being passed to nationalize the Minerva Mills, because Minerva Mills is undergoing losses. Now here the question is coming that whether the directive principles of state policy would have primacy over the fundamental rights conferred by Part 3 of the Constitution of India. The question herein goes like that, the answer herein goes like that we cannot say that directive principles can override Article 14 and Article 19, because just 2 years back in 1978, we are having Maneka Gandhi. Maneka Gandhi is saying to us that Article 14, 19, and 21 forms the part of a golden triangle. They coexist together and they ensure the fundamental freedoms to a person. So when you are saying that Article 14 and 19 can be overridden by the By giving the primacy to directive principles of state policy, we are basically violating the fundamental guarantees as well. So one of the basic structure doctrines that was laid down in the case of Keshwan and Bharati is also that there should always be a balance, harmonious construction of directive principles of state policy and fundamental rights, because the two are not contradicting each other, the two are supplementing each other, they are supplementing text, they are supplementing each other's purpose. So fundamental rights cannot be read in isolation of directive principles and vice versa as well. Therefore, court herein is saying you cannot say that primacy shall be given to DPSP and it can override Article 14 or 19 as well, but rather they both shall be harmoniously construed so as to give the meaning to the dynamic constitution we have, to the constitution that is progressive in nature and that is providing, that is manifesting equality, freedom, and distributive justice for the citizens of its country, right? So this was what was held in the case of Minerva Mills. I hope this discussion was useful for you. For more such content, please stay tuned with us at Legal Darshan. For any information, suggestion, any kind of communication, any help, any feedback, you may reach out to us at legaldarshan@gmail.com. The email ID is given in the description box below. Thank you for watching. Have a nice day.